So welcome.
And perhaps good to just introduce ourselves. Oh, I can't push forward to the next slide. Now it
There we are.
works. My name is Hanneke Zandvoort. I work here as a lawyer. I'm a Dutch qualified lawyer. I have over 8 years of experience, and I work in the field of national and international private law and insolvency law.
And hello, everybody. My name's Tessa Plews. I am also a lawyer. I'm an English qualified lawyer. I have 7 years worth of experience, with the majority of those practicing in England and Wales. And I lead here at Bearden's the UK desk and the common law countries for dispute resolution.
Well, this is a small overview of our office. We have offices all around Europe, and we cover debt recoveries in all the blue countries that you see on this sheet. Today, we're focusing on problems regarding the UK, a topic interesting for actually all the European countries and especially for EU countries. So, Tessa, we all have heard about Brexit, but yeah, it was a bit chaotic. But actually, what is the Brexit?
Yeah. I think if you haven't heard of Brexit, I would be quite concerned. Of course, it had a huge international impact, and it was, as we've got on the slide there, all over the newspapers with some rather interesting, shall we say, headlines. So Brexit, for me, is sort of broken down into three clear stages. We've got 2016, where the actual vote took place, the referendum. Then we have a period of withdrawal where some EU rules still applied. And then we have the actual date that the UK left the EU. And for the purposes of this webinar, it's the 1st of January 2021. And that's a date that I will keep on and we will keep on coming back to when we're referring to what's the difference, what's the change. It's that critical date, the 1st of January 2021.
Perhaps also good to mention in front is when Dutch people have it about the UK. When they talk about the UK, they usually say England. But is there actually any difference? Can you tell me something?
Yeah, of course. So the UK, it consists of those four countries that I've listed there: England, Wales, Scotland, Northern Ireland. Now, across those four countries, we've got three jurisdictions. So the first is England and Wales, that's one jurisdiction, Scotland and Northern Ireland. And what's important for you guys to know is that within those three jurisdictions, we have different court systems and we have different laws which are applicable. So a really, really valid question. I think for myself, who I am British, it sort of goes without saying, but I can understand, obviously, the complexities of that. And in addition, I've made a note there about Northern Ireland and the Republic of Ireland. So remember, the Republic of Ireland is still Europe post-Brexit. So that's where the interaction with the Good Friday Agreement, open borders, and some of you may have seen recently that Rishi Sunak obtained an agreement with the EU pending approval. So that's why that topic is quite hot at the moment. And I think for us as practitioners is that could have some implications for future agreements with the EU and what that relationship looks like. So that's why I've just made a little bit of a side point there to just highlight that is of some relevance as well on this topic.
Okay, thank you. Here we see some points, because there's always a debate about whether the EU is beneficial or not. Here you see some advantages about the customs passport. Can you tell me something about what has changed due to the Brexit?
Exactly, and I won't be sharing my personal opinions here, but of course there were substantive changes after Brexit happened. So we now see, of course, the freedom of movement. There's visas which are required both ways. We've got the customs border, which is probably for the people that we've got online. That's really important, that the customs border, of course, has an effect on the trade. For example, duties, customs, VAT, different rules now post-Brexit, which has had quite a lot of disturbance in a lot of industries. And an example that I put there is, EU buyers of British-made items now have to pay their own national VAT, whereas normally it was the British UK VAT, which is normally a little lower. So these are some of the sort of real changes that you can see on a day-to-day basis, and how that then obviously impacts the trade and the movement of obviously people, goods, etc.
And is that also why you see here the big traffic?
Yeah, exactly. What I was trying to demonstrate the point there is, customs post Brexit. You've heard some stories of, large, tailbacks and large traffic for the border, and quite a lot of news around that one that hit the British newspapers at the time. I remember it quite well. Was that the Dutch customs had intercepted British lorry drivers with their ham sandwiches, and their ham sandwiches were taken off them, for example. So yeah, it's had quite big changes, both on a macro level and also perhaps maybe on a more individual basis as well.
Thank you. And perhaps interesting for today, what should our credit managers be aware of?
Yeah, I think this is a really great opportunity to just highlight that Brexit has had some, of course, those day-to-day changes that we were just talking about, but it's also had some quite different impacts in terms of the risk and uncertainty for credit managers and credit management generally. So the key point I want to get across is that post the 1st of January 2021, that's the key date that I was just talking about of Brexit, I see it as increased risk and increased uncertainty. And why do I say that? Of course, well, firstly, the enforceability of EU judgments. So we're going to go into more detail on that on the next slides. But just as a summary point, the enforcement of these EU judgments is not the way it used to be, and that can increase risk.
So if I have a case running in the Netherlands, I obtain a Dutch judgment, and for example, January this year,
Yeah.
On a English debtor, what will happen to the judgment?
Yeah. So it would all depend on when those proceedings were issued at the courthouse. And that's a really, really critical distinction between the two regimes, which we'll touch upon. So if it was pre-Brexit that you issued those proceedings, then we would proceed under the old EU rules.
Even if the judgment is after Brexit.
Exactly. And actually, we had a key case that we dealt with here at Buren's where we argued exactly this, and we were successful. The proceedings were issued pre-Brexit, therefore Brussels regulations to allow the enforcement to go through. And the second sort of topic that we're going to go into a bit more detail about is the general terms and conditions, and how we can make sure that those can really safeguard your position, and to make sure that they're up to date, that the risk that you're trying to offset in those agreements, general terms and conditions, are actually what you can get in the end.
Okay, perhaps getting back to the case, gaining a Dutch judgment on an English debtor and gaining it after the Brexit, but the procedure was issued before Brexit.
So as long as those proceedings are pre-Brexit issued at the courthouse, then we're going to be able to proceed under the old EU rules. So I've put them in there, the Brussels and the recast Brussels regulations. What's going to be very critical is if you, let's say, issued on the 2nd of January 2021, so after that cut-off date, those no longer apply. The Brussels regulations no longer apply. The enforcement, therefore, is narrower than it was before. Now, I don't want to bog everybody down with all of the detail and the legal arguments, but it really is a much narrower enforcement route that you can go down now in those UK countries. And critically, if, for example, one of the routes now that you have to go down is to issue new proceedings, then your debtor's ability to challenge that debt and challenge that judgment is going to be much wider than what we used to benefit from under the Brussels regulations. So I think that's a really, really key point. And the final point there, it really requires case-by-case specialist analysis. If there is a different route that we can go down, for example, bilateral treaty, etc., we will look at that on a case-by-case basis. So it's key to note that it certainly isn't what it used to be pre-Brexit that we now have to follow.
So perhaps can general terms and condition give a solution?
Yeah, I think so. I think, before Brexit, parties could use their preferred law, their preferred court location, which is generally speaking home law, home court, because you could rely on the enforceability of that judgment. So whether that be a Dutch, German, Spanish, French judgment under the Brussels regulations, you knew that you could enforce that very straightforwardly in England and Wales, for example. So now a key point that I want to get across is that if you've got those general terms and conditions that haven't been updated, which we often see in the practice that we have here, they haven't been updated, we need to make sure that they are serving your purpose, that they're safeguarding your position in an event of which, the debtor hasn't paid, for example. And just on that point, Brexit has had an impact on the economic situation in the UK, coupled with COVID, the Russia-Ukraine invasion. So we are seeing an increase in those payment defaults. And it's just to note that you do have somewhat reduced leverage to obtain the judgment. So that's why we want to make sure that your agreements, your general terms and conditions are really up to speed and protecting your position properly.
So should it be a good idea then to apply always UK law and like English law and an English court, so you're sure that you can enforce it on your English debtor?
That may be a type of an interim solution, and that may be something that parties wish to consider when they're entering into new agreements or when they're drafting their general terms and conditions again. However, do note that, for example, English law, you need to have specialist knowledge on what English law would bring that's different to your home law. For example, if you're a Dutch creditor, what are you signing up for when you agree to English law? So that's where you need some advice. For example, the law is different on product liability, etc. So it's really important that you understand that. And secondly, there is something to be said that if you're in an English court against an English debtor, it is on their home turf. It's not your home turf. So that can be somewhat of a drawback. And one thing that I see a lot in my work here is the cost difference is quite a surprise to a lot of clients. Generally, English litigation is very expensive and quite often disproportionate to the sums that are involved and different cost consequences. So that could be an interim solution, which you should certainly consider on a case by case. But the other branch that we've almost talked about there is arbitration.
Can you tell me something about arbitration? Because what is it actually?
Yeah, so for me, arbitration can be seen as its own separate proceedings, which is similar to a court proceedings. You agree it by putting it into your agreements, your general terms and conditions, etc. And it's on your terms. So you pick what we would say in the court system, your judges, but in arbitration, your arbitrators. You are able to say where that forum is, how many arbitrators you would have, for example, and that's how arbitration sort of looks different to the court system. And with that, you get an arbitration award, not a court award, which is quite important.
So I choose Dutch law applicable. I do the procedure in the Netherlands with arbitrators that I've chosen myself. And then we gain sort of a judgment that is mentioned differently but has the same effect.
Yep.
And I can execute that in England.
Yeah. So for all intents and purposes, it sounds like a judgment, but it's called an arbitration judgment, which is critical because there are different rules which apply to the enforceability, and that's on an international level. So you are able to import your Dutch arbitration award into the UK far easier than the current status on court awards.
But what I always hear about arbitration, that is really expensive.
Yeah, I think that's one of the first things that I always hear, and I somewhat agree. There is a upfront cost involved with arbitration, but the point that I want to make is in the situation that we spoke about in the beginning, Dutch court, Dutch judgment, you've got high risk in importing that into England, and you've also got a high cost as well. So those two things together, I think somewhat makes arbitration more appealing, and certainly from the enforceability of the judgment. But of course, cost is always going to be a factor which we would need to advise you on, that we can obviously discuss strategically whether that is something which you wish to proceed with. I think that sort of links onto this point about the developing situation, and it was one of the points that a really strategic approach is required, because this is a really fast changing area of the law. As we've seen, it's very sort of politically sensitive. We've seen obviously with the agreement with the Windsor Agreement, so that's a Northern Ireland and Republic of Ireland situation. That happened, and now potentially new agreements are going to come, and we're able to look more at those types of future agreements with the EU and how that relationship works going forward. So myself and our team are really watching those situations. Of course, if there's a framework in which we can effectively resolve these issues, fantastic, and we will be sort of on the front line looking at that. And that's where the cross-border expertise works. I mean, we've worked on a few cases together, and we're able to come together and really explore what is the best way in which we can secure this.
Yeah, because what clients can think is that another good solution would be apply Dutch law for an English court, but our experience is that is a horrible idea.
Yeah, exactly. And I think that is something that's quite difficult to argue. There's always going to be a difficulty. I mean, it is possible. In theory, it's possible, and we do have experience doing that. But that takes quite a lot of investment to make sure that the court really understands what the applicable law is, why it's different, and why you want certain elements to your claim, instead of what maybe that judge is used to on a day-to-day basis.
And I also see a question coming in. What if the debtor does not want to pay their share of arbitration?
Yeah, it's a really interesting question, because it's something that we see, we come across in our practice, and fundamentally it can be a breaking point for negotiations. If there isn't that sort of undertaking to pay that fee, then that is a matter which we can raise in the arbitration itself, and make the point of the same. In my experience, it doesn't stop the arbitration going ahead, and there are resolutions that you can come to in order to make sure that certainly does go ahead. And it may be, for example, that you ask the arbitration to deal with that issue.
If there are any other questions, please feel free to put them in the question box.
Or alternatively, if you maybe need more time to reflect on all of that information that we've given to you, we also have our emails on the very last slide, which maybe pop through to you now. We're more than happy to answer any questions after the webinar, and we're able to come back to you with anything in particular. And I think that the take home for me is that if you're in a situation where you're concerned, even if it's something that a level of debt that you're willing to tolerate at the moment, but that debtor is in the UK and you're just a bit concerned, feel free to reach out. I'm more than happy to discuss cases with people, and we can certainly advise on the strategic approach if the case is obviously at such a point, and we can look at your options, because I think it is really important to understand that things really have changed, and it may be a time to call on that advice maybe sooner rather than later.
Yeah, perhaps also that you don't use general terms and conditions for all of your clients and always use the same ones, but use different ones for your UK debtors, for example, or put an arbitration clause in only those terms and conditions.
Definitely, and maybe grouping those the application of those general terms and conditions a little bit differently. Not just because it's an English-speaking country, so use your English general terms and conditions, but really think that the UK is, outside of the EU now. How can we make sure that there's a strategic approach to that to safeguard? Good. I can't see any more questions at the. Oh, I can.
Would you be able to draft terms and conditions for UK customers. That's the other way around.
Yeah, so that hasn't been the topic of the conversation today, but absolutely. And what's very useful about our setup is that we have the specialists in a majority of the international jurisdictions. So if you are, for example, a UK customer who has exposure through German debts, Spanish debts, French debts, we're able to look at those to make sure that the other way around almost, so a UK creditor with a European debtor, we're able to make sure that, again, that you're safeguarded.
For example, like we work together as well. A couple of weeks ago, we had a Teams meeting with the client, so the client could be informed about both the English law and the Dutch law at the same time. We could explain what were the advantages of Dutch law or what were the advantages of English law. So it's always useful to work together and have both knowledges.
Yeah. Right.
Ooh, question. Is the exequatur procedure feasible after Brexit? Perhaps it's first good to explain a little bit about that procedure.
Yeah. So, in terms of that procedure, of course, it is possible. Absolutely.
Because perhaps good to say the exequatur procedure was actually before we got Brussels. So before there was a European regulation, well, you also had to start like an execution procedure. Go ahead with your judgment.
Exactly. And I think what's key is that is wider than what we enjoyed under Brussels. So again, it's a distinct procedure. Absolutely possible. And it's key just to note that, you know, that is going to incur further risks and further costs versus what you were used to. And it involves, I don't want to go into the nitty gritty of this because I know that not everybody wants the level of detail that I enjoy on this topic, but it's a bit more technical and it is possible, but it's a way that we need to really analyse about how those initial proceedings were instigated, which can seem a little bit backwards, but so that's why it's quite important to get the advice before you've even done your French, your German, your Dutch proceedings. That's the real key, the key point, because under the English jurisdiction and indeed a lot of the common law jurisdiction, it's going to look at the time that they were issued, what was the situation. So a little bit retrospective in that.
And we earlier on mentioned question, would you be able to draft terms and conditions for UK customers? We now see an amendment. Sorry, I mean, if I'm a Dutch company and want to deal with UK customers. So then you have like a Dutch company and a UK debtor.
Yeah. No, absolutely. So both ways we can absolutely deal with that. So that's either a European into UK or UK into Europe. We can absolutely look at those general terms and conditions. And for the reasons that I highlighted on the PowerPoint, I really strongly recommend that that's done sooner rather than later.
And that's also what I mentioned, that perhaps it's good if you're a Dutch client and you have a UK debtor, that it's good to have different terms and conditions for that UK debtor than for like, for example, the German debtor, because there nothing has changed. Another question, do you suggest arbitration also for credit recovery?
Yeah, for me, credit recovery.
I guess debt recovery.
Yeah. That's what I take from it. So if that's on the basis, and of course, this individual, if we haven't understood that correctly, then comment again saying, no, I didn't mean that. But on the basis of any debts, I mean, as long as there is a credit function and there is a debt due under that, either agreement or invoice, that's absolutely possible. Arbitration, I think maybe where the question's coming from, of course, is you often hear arbitration in private matters. You hear a lot of sports arbitration, for example. But absolutely, for big companies and indeed for, any debt, you can absolutely use arbitration. Sorry, it isn't a clarification. It's a different question, but yes. So for any credit, any debt recovery, you can use arbitration, but note the points that obviously we mentioned before.
Another question, is a verdict or a judgment coming from an arbitration procedure immediately enforceable in the UK?
It's not immediately, but there is a procedure which is followed, which at the moment, and I'm really making sure that I don't go into the real depths of the legal argument here, but yes, there is a procedure, and it's far more straightforward than the current state of affairs with those court judgments.
So it's more like a checklist instead of a completely new procedure.
Exactly. And I think that's the hardest thing at the moment with the court judgments is it's very unknown and it's very uncertain without that framework. And the arbitration proceedings and judgment, they have that framework which is fully established in all of the jurisdictions that we've discussed today. Good, some really good questions.
Yeah.
Oh, another. Oh, two more coming in. Okay, so
what about if we don't have yet review or general terms and conditions providing arbitration? Which procedure would you suggest to get payment of outstanding invoices? And then I guess it's a Dutch client with an English debtor.
Yeah. So I've read this to understand that there's no thank you. There's no arbitration clause. You've just got Dutch law, Dutch court, and you've got a UK debtor. Simply put, we're going to have to look at the situation. We're going to have to look at the values, etc. There is going to be a route. It's just what's the best route and what's the most cost-effective route. So I think on a case-by-case basis, it would be very interesting for us to maybe have a discussion about that. There is a possibility, it's just which one, and that's really going to go down to the facts, which I think really demonstrates my point that before, pre-Brexit, we could have just said with some certainty, this is the solution, this is the answer.
Yeah, then we would have said, just get the Dutch judgment and execute in the UK.
Yeah, whereas now it's obviously a little bit different.
Another question was, you mentioned a couple of times that arbitration is expensive. For what debts, from what amount on and upward, would you say that it's sensible to go to that route?
The golden question. And I think it's, it really, I know a lot of the arbitration fees, for example, depend on the value of the claim. So it's sort of intertwined. So the higher the value of the arbitration, the higher you're going to have to pay in your fees and indeed your arbitrator's fees. For me, as a sort of it's a rough guide, I think for me, something over, let's say, 30,000 might be interesting to look at that proportionally. But you can be surprised on this, and I think sometimes it depends on the forum. So each arbitration system or type of arbitrator has their own fees. So it depends upon which you've agreed there. It can be proportionate to the value. And if we then almost do it in an Excel spreadsheet and look at what the alternative cost would be, Dutch law, Dutch court, enforcement, risk, that could be quite a good exercise to justify those upfront initial costs.
I think another example, German creditor, UK debtor, German law and jurisdiction.
Yeah, so I think this is linked to that question that we just talked about there. So So
we answered it as was it a Dutch client, but actually I would say there is no difference.
So I think that's in relation to the question about arbitration. So at the moment they've got so exactly, and I think it's going to be case sensitive. And of course, in that situation, you can do German law, German arbitration. You can pick your arbitrators who are specialists in the area in which you trade. For example, if you trade, I don't know, in steel, or you can make sure that, you choose those arbitrators who really understand the industry and really understand what the dispute is.
Yeah, and that can be an advantage according to like a normal judge, because they have no idea about all the specific work that you do. Like when you sell books, they understand what you're doing, but there's so much technical work that a normal judge has no idea what you're talking about, that it can be really attractive to have an arbitrator who knows that field of work.
And that is coming up to the 30 minutes. And I think that was a great interaction. So thank you so much for everybody who put questions into the box there. Again, our emails are on the slide. Feel free to reach out and we will be happy to discuss any cases with you. Thank you for your time.
Thank you and have a nice day.